So let me, I'll kick off and then Reed, maybe you want to say in the introductory. So this is the first of all, thank you for joining us this evening. And it's a pleasure to be here and to see so many boxes. It's kind of intimidating. And this presentation, Kit used the word presenters, but for this one, I don't love that term. Because our view on this one, we're hoping it's more interactive and address the kinds of concerns you have with respect to startups, rather than Reed and me just pontificating on the subject. And for that reason, I didn't prepare a whole bunch of PowerPoints and all that good stuff. I mean, I'll do a little introductory beforehand, but I'd much rather address the issues and concerns that you have on doing it. I've only been I've gotten a lot of LinkedIn messages of recent because I think I've just celebrated my 36th year. Practicing. So I've been doing it for a little while. And so I've seen a couple problems. And so the purpose here is both to provide you with some guidance, but maybe even find a few mistakes that people have made along the way and help us to avoid that. By way of introduction of the thing, I always, and maybe it's a good way to start because we do one session that's called All About the Exit. But I've told folks before that when we do startups, I think about things with two hats in mind. One is the potential acquirer, and one is a potential investor. And as you embark from the very beginning of the startup, from the very beginning, if you think about it as the exit and aiming toward that, it will make your life a heck of a lot easier when you go to sell your company, and actually will create value for you. So, for example, some of the things we'll talk about regarding IP and proper corporate management and all those kinds of things, and forming it correctly, and all those things will position you both for capital to be raised and not trigger issues as you go to sell your company. So that's the part of the reason we start here is because I want to get you to an exit at the end of the day where you're going to maximize the value if that's what you want to do. So that's point one. So I'm happy to talk a little bit about corporate formation, which seems to be always sort of interest to folks, including sort of the founders and their arrangements. We could talk a little bit about IP if you'd like, and we'll do a little bit about that. We could talk about contracts and raising capital without a huge amount of detail. And each one of these, by the way, they're teasers because we'll do a whole in-depth Start Smart series about each one of them. But again, if there are things you'd like to delve into a little bit more, I'm happy to pontificate about anything and go back and forth on those things. So let me pause there for one moment before I go, and I'll start maybe with formation. Well, let me do, but first let me turn over to Reed and say, Reed, anything from an introductory side you'd like to say before we go on?
Yeah, thanks, David, and thanks to Kit and Stephanie and Jessica for organizing this, and good to see you all, see your little boxes, I guess. So as Kit said, I've been working at CMU for 15 years. I was at Pitt for 10 years. I was at the Life Sciences Greenhouse. I was at the Ben Franklin Center before it was Innovation Works. So similar to David, I've been working in this field for about 35 years. So most of the things that I would be able to answer your questions on relate to the university processes. So that would include things like interpretation of the university's intellectual property policy. And of course, I'm going to be more adept at doing that on the CMU side than Pitt side because I left Pitt 16 years ago and there's been changes since then. So IP policy, how it relates to your individual activities is an important starting point. IP protection. So I've been involved in the tech transfer office for many years and we file patents as our business. So we know the process in and out, what to do for a provisional patent application, full patent application, how to do patent searches. So any of that's fair game for you to ask questions. And then when a university owns a technology and tries to get it out to a company that can practice and use the invention, the process is called licensing. So you're giving that legal right to use this property for particular purposes. So I can talk about that generically, what different types of licenses you do with our IP. And I can talk specifically about how CMU approaches licensing to startup companies. I can also talk some about restrictions on IP that might come based on funding sources. If you have government funding, or if you have a grant into your company, or if you have open source software that you're using, like all of that can affect the rights that you have to go ahead and commercialize your technology. So I think that sort of complements what David's going to talk about, and we look forward to your questions.
Thanks, Reed. Anything as a preliminary matter anybody wants to hear about before? Maybe I'll talk about corporate formation unless there's something somebody would like to talk about before that.
I'd just like to, for the startups in the audience, David, just talk about the two basic types of businesses there are. There's, high tech, high growth companies that, as David was talking about, are shooting for an exit. There's also other types of startups that are not necessarily companies that would be acquired, and they're certainly perfectly fine and valuable, but it's a slightly different path and different assumptions that go along with it. So, hopefully tonight, as we're talking about strategies, most of the strategies are going to be related to those high growth companies shooting for an exit. But if you're part of a company that does not have that as a strategic objective, that's okay too, but just keep that in mind as we go forward.
I think that's a great point. And that actually, that goes to when we talk about formation, and that goes to one of the things we start with is, should we form an entity and what kind of entity should it be? And you all have probably heard much about this along the way, but there's many choices, whether it be limited liability companies or C-Corps or S-Corps or benefit corporations or limited partnerships or partnerships and nonprofit corporations, to name just a few. And I probably want to, since you're thinking about a startup company, one of the most important things is why to form an entity. And I do think it's important to spend one moment on the question on the reason, which is liability. We are very fortunate to have systems in place in which you can form up a company and the liability is limited to that entity, so that you as an individual, a shareholder or owner, regardless of how it is, don't have any liability for personal liability for that entity. That's an interesting concept, right? Just step back. I can form an entity, it can do whatever it wants, and I personally am not liable for the debts and obligations of that entity. That's a pretty cool little system. And you're only liable for what's actually you put into that entity. Now there's some rules to go with that, but that's, if I'm going to pick a reason number one to form an entity, that's it, limiting liability. Now, the way to screw that up is not to adhere to corporate formalities, which is if you create an entity, you got to really treat it like an entity. You got to have separate bank accounts, you got to have your board meetings, and you got to do all that. Otherwise, people do what's called pierce the corporate veil and hold the owners, shareholders, or members, depending on what kind of entity it is, liable for that. So point number one in startup company is to start a company. And the principal reason to do that is limiting liability. Now there's some others, but that from a legal perspective, that's a pretty important one. A second reason is to house the assets, right? I want to put all the assets associated with this company in one place. And one is the IP, and we'll talk a little bit more about IP, but sort of put all the entities in a single place. So we'll come back to that in a little bit. The next question, and by the way, one way to sort of mess up. So we've done this thing of creating an entity. We'll talk about which one in a moment. We've limited to the owner's liability, which is a good thing. But then people go and sign personal guarantees, which sort of undercuts the whole purpose. So if you're signing personal guarantees, you're creating limited personal liability. Sometimes for startups, people get a little sloppy and they use personal credit cards, and they run up personal credit cards in connection with startup companies, which is okay if that's what you want to do. But again, you're creating personal liability for the debts and obligations of that. So know that that's sort of an issue. I joked a little bit about the number of entities. As a general matter, the choice is if you're going to be a for-profit enterprise, as a general matter, your choices are come down to a limited liability company versus a C corporation. And there are some pretty good, mostly tax reasons to go one versus the other. S corporations, LLCs have a single layer of tax. They don't actually pay tax that goes flow through the individual. There's some, so that's a benefit to a limited liability company. C corporations, so a single layer tax really important. That's good. C corporations have some advantages from a tax perspective because if there's something called a qualified qualified corporation, which small corporation, which basically if you qualify and you hold the stock for over 5 years, you don't pay any. If you sell the stock, you don't have any capital gain. It's subject to lots of limitations, but that's a very there's some tax rates which are kind of nice. And zero is my favorite tax rate. So that's sort of a nice thing to do. So so there's some tax considerations associated with it. And so the purpose, my sole point there is once you decide you're going to form an entity to limit your liability and to house the assets, then let's think about what kind of entity it is. And that's probably somewhere where you want to sort of pause and think with a lawyer about what the kind of entity that's going to be. Two caveats to that or points. One is if you're a VCs generally will not invest in limited liability companies. They'll invest in C corporations. So if you're targeting toward the high growth, the high growth model that Don was discussing, then you probably want to lean toward a C corporation. If, on the other hand, you're going to be less of a high growth and perhaps more of an ongoing business, which is great, then maybe a limited liability company may be more in line for what you need to do. I just saw the right question in the chat box, the chat room, which is that it is very, very easy, relatively easy, to go from an LLC to a C corporation. Thou shalt never go from a C corporation to an LLC. So I'll say that again. You can go from an LLC to a C corp. You can't go from a C corp to an LLC. You can, but it's tax inefficient. You got to pay lots of tax to do it. So when in doubt, and it's better to start with an LLC and then you can convert to a C corp. You don't start with a C corp and then convert to an LLC. Kate, you look like you wanted to say something.
Yeah, well, I was just going to do my one caveat that about forming the company early. If you're a student here on the F1 visa, wait till you're on OPT before you form the company. The F1 visa only allows you to study in the United States, but it is not an authorized work permit. You can own a company, you can form a company, but you can't work on or for your company. So it just keeps it clean. But there's so much you can do before actually forming the company, a lot of research, MVPs.
Oh, absolutely.
Lots that you can do beforehand. So important you avoid the forming the company to legally do that.
If I could, what we see at Blue Tree is many early stage companies, for simplicity's sake, start off as an LLC during their early years until they get going. And then when they start going out to raise serious capital, that's when they convert from the LLC to C Corp, because most investors want the benefits of a C corporation from a tax standpoint. As David said, it's easy to go from LLC to C, but not the other way. So that's what we see a lot of companies doing, starting out as LLC and going to C Corp. If your funding strategy is more aggressive, where you're going to go out and raise money right away, which is something most companies can't do or don't do, then you should think about your initial organization as a C Corp. So your funding strategy and timeline should really drive your operation strategy.
I agree with that. One of the other benefits to the, if you have a pretty good sense that you're going to be a C Corp, there's some benefits to starting as a C Corp, in part because you're starting that 5-year clock early. And so that's helpful so I agree with you. I've seen in the last couple of years, more and more of the companies from my sense are if they're going to do the high growth, they start the C Corp up front and just go with it. But I agree with you, Don, that certainly starting an LLC and then converting is helpful. And to your point, actually, some of those initial investors kind of like an LLC up front, because then they can take the tax losses from and pass it through and use those losses from the early years as an early investor. So that's cool.
So
So
Dave,
what was? Yep.
you say you can actually see it because you don't have a PowerPoint, but they wanted to know, can you talk again about the 5-year clock?
Sure. So this is the QSBS. I think I forget the initials. And this is the thing that says, okay, it only works with C corporations. And what it says is if you buy stock from the corporation initially, from a small from a corporation, and you hold the stock for more than 5 years, and we sell the company, and it's a qualified kind of corporation, which means it provides, and there's some exceptions, like it can't be a consulting business, and there's some other exceptions to it. But putting that aside, but if it's a qualified corporation, you can, when you sell it, you get a capital gains rate at the moment of 0, and it's up to $10 million of I believe of exclusion. So up to like $10 million of that is excluded. And I have had clients in the last number of years really enjoy the benefit of that. And so, but you have to. It doesn't work with LLCs. It doesn't work if you are an S corporation then convert to a C corporation. So it's important to and if you go from an LLC to a C Corp, it will start from the time you start the C Corp, and it'll be the value at that point to the value that you ultimately to exit. So you lose a little bit of the benefit of it. Was that clear as mud? So the point is that if you are there's some significant tax benefits to a C Corp if you're going to sell. What was that? I didn't see that. Sorry. I'm trying to read the chat questions at the same time.
What is the name, I think, of this provision you're talking about?
It's yes, it's the qualified small business stock, QSBS. Cool.
So I have a question talking about Don's comparison between lifestyle and high-tech companies. Are sort of long-term lifestyle companies more likely to start out as an LLC than a company that thinks it's going to need an infusion of capital pretty quickly?
Yeah, yeah. I mean, a lifestyle company would usually be an LLC, and I should pause there for a moment and say, there is, yeah, exactly. Somebody just asked about S corporations, so that you guys are ahead of me. So if you're a, and I don't want to use the word lifestyle corporation, but not a high growth capital intensive company, you might also think about as an S corporation. An S corporation is taxed like an LLC with the benefit of the pass through. It has some pretty rigid requirements. You can only have one class of stock other than voting and non-voting, but you only have one class of stock. Only individuals as shareholders. You can't have corporate shareholders. There's a limitation on the number of shareholders. I think it's 75, but I actually have forgotten because I haven't done it for a little while. And there's some significant limitations to it. But it is a elegant, simple way. If you're not going to get much investment, an S corporation is an easy way to do it. There's some relatively modest tax advantages to an S corporation to an LLC, if that's the kind of because of some employment tax things I will get into. So there's some actually modest benefits to an S corporation over an LLC if your plan is to be sort of a more of a lifestyle, and I don't mean that in a negative way, kind of company. So if you're not the high growth, I would talk with your lawyers about whether it be an S corp or an LLC. And if it's possible that you're going to go high growth, then go LLC and then convert later.
David, could you expand on the stock provision you were talking about? Is there a difference between buying stock purchase versus founder stock that's been granted?
Yeah, it's they both count as long as you acquire the company. As long as you for that purpose, as long as you get the stock from the corporation. What I'm distinguishing that from, sort of not too subtly, is that what doesn't count is buying it from a shareholder or from a third party. So if Don and Kit start a company, I come in and I buy Don's stock, I won't qualify. If I buy the stock directly from the company, then it qualifies. Certainly, founder stock counts, and certainly investor stock counts.
Sorry, can I interrupt just 1 second, please?
Yes.
That purchase of stock needs to be registered as a bank transfer, or could it be done in cash? Or, I mean, if the funder is the person who owns all of the shares, when the first investor buys, it buys from him, right? Not really from the corporation. Or how does this transaction gets registered, or what are the documents that need to be produced to account for this first transaction? Please, thank you.
Yeah. So let me. Actually, let's take the most simplistic view: one founder, and the founder buys shares of a stock, okay, shares of a company, and let's call it a C corporation. Actually, the investor that comes in will actually acquire shares from the corporation. So they won't acquire it from the founder. They'll acquire shares from the corporation. The corporation will issue additional shares. So, for example, if I have 900 shares, and I want to give somebody 10% of the company, then they're going to buy 100 shares from the company. If I said 900, so they'll have 10% of the company. And so they'll put money in the company, and then so typically we're not putting money in the founder's pocket. It's not buying it from them. They're buying it from we're trying to infuse capital into the company, and therefore they'll buy the stock from the company itself. Okay.
Yeah, if I'm a founder though, I'm not
What's
buying in stock.
But that wasn't. I thought Roberto was asking about this next investor.
Got it.
The next investor.
Yes. Thank you. It answered my question, but there is a little detail that maybe you can elaborate. Okay, the second investor buys from the corporation, which is, thank you for that answer. It clarifies my question. But at the same time, what proof we need to, do we need to collect a proof that payment was done, or it is just a document that we sign, or needs to be a bank transfer? Is there anything?
Yeah, so when they do that investment, they will sign some piece of paper, likely a subscription agreement or investment agreement or something like that. And they will get, and in exchange for that, and there will be some kind of a transfer of cash or wire transfer or something for the funds. And you do want to document that in some way, so you have it's traceable audit for an audit. And then you will get either a real or a virtual share of stock in exchange for that. And I'm strongly encouraging startups to use one of the online platforms or one of the platforms for startups to use for capitalization management or stock management, because these systems are really good at keeping track of the options and the stock and all that stuff, and take all that off your plate, creating cap charts, fancy cap charts for when you get fancy investors and all that stuff, and creates a mechanism that will help you later when you get more complicated, and ultimately if there's an exit. So, in answer to your question, Roberto, one of the things you would do is go on either the one I use is Carta, which is an online service that keeps track of all the capitalization and all that stuff, and how it grows with you. And they have very modest charges to get you online, because they want you when you get bigger. And they do one more. I'll give them one more pitch. There are others, but it's the one I happen to use for startups. And we'll get into employee equity later. But when you give employees options, you have to do it at fair market value in order to have appropriate options. Give them exercise prices. You have to do you should do evaluation for that, and CARTA will do evaluation for a relatively modest amount. So that sets the stage for that. So my point is that there's a startup. I would, when you issue new shares and do all that, I would get on CARTA as soon as you can.
Thanks.
That was a long time on just type of entity, but I do want to go on that there are other forms beside LLCs, S corps, and C corps. There's nonprofit corporations. If you don't plan to ever make a profit and take foundation kind of money, that's important. There's also benefit corporations that we'll get into, so there's other kinds of entities, but those are by far the most common for for-profit companies.
So Reed, you might want to take this next question in chat.
Which one?
Look at it,
So just for the recording, how early should a startup begin to look for patents? Or how can they deal with doing customer research and giving out their idea without having patented their idea if it needs patenting?
Okay, so I'll give a couple answers to that. The first is you should always have a way of talking about your project that doesn't reveal the how. Like that should be a black box. You can talk about the problem, we have the solution, here's what our benefits are. And if they want to learn more about the how that you're doing it, the enabling details from a patent perspective, they should sign a confidentiality agreement. So investors, when you first talk to them, will kind of be put off if you ask them to sign a confidentiality agreement. They just won't do it. They'll think you're an amateur for asking. So you have to have a way of talking about your work in a non-confidential manner. So that's one part of the answer. The other part of the answer is when I mentioned enabling details, that has a specific meaning in patent law. And it comes about one of the criteria for whether something is patentable is whether it's novel. And everybody has sort of an intuitive sense of what novel means. It means that nobody's ever done it before. But there's a hidden sort of legal meaning of what novel means. It's like you haven't described it, you haven't revealed it to the world yet. So most of the world has an absolute novelty standard, meaning if you've described the enabling details to the world, and I'll come back and define world, if you describe the enabling details in a public way, it's no longer considered to be novel and you cannot get a patent. So the US has a 1-year grace period after disclosure of enabling details where you can still file a patent, but the rest of the world is basically, you've lost your ability to get a patent as soon as you disclose enabling details. So what are enabling details and what's a disclosure? So enabling details are enough information such that someone else, here's another term of art, someone skilled in the art can recreate your invention without undue experimentation. So are you giving enough information that somebody else has similar knowledge as you do can recreate it? And it's kind of a mushy kind of definition there. And it's hard to say in a blanket way what's enabling in a situation or not. Sometimes you could just say the title of what you're working on. Like, we're combining this gene with this vector to treat this disease. Like, oh, well, I can do that because I know what the vectors are. I know what that gene is. I know what that disease is. But if there's like hidden stuff in there, like, well, you can't just combine them. You have to do it in a special way. That part is the enabling stuff. So when you're doing an abstract for a conference, if you just sort of talk about your approach and your results, is that enabling or not? Maybe yes, maybe no. And that's the kind of thing you need to think about, because if it's enabling, you haven't filed a patent application first, you've lost the ability to patent in most countries of the world and started this 1-year clock in the US. So the next part to talk about is like, what's a public disclosure? So basically, it's anytime that you're giving these enabling details to someone who's not under an obligation of confidentiality. So obviously that would be something like publishing a journal article, speaking at a conference, but it could also be sending an email to somebody. If it has enabling details in it and they aren't under an obligation of confidentiality, that's a public disclosure, same as putting it in the New York Times. So you have to be careful about those things. What's an enabling detail? And what's a public disclosure? So your grant applications, your manuscripts, when you put them in, are being reviewed under an obligation of confidentiality. Once the manuscript is approved for publication and goes out even electronically, that's a public disclosure. You've lost your right to file outside the US, you start the 1 year clock in the US. Similar for your grant application. You file it, it's confidentially reviewed. When it's awarded, it's subject to access through the Freedom of Information Act. So even if nobody ever does that Freedom of Information Act request, just the fact that they can makes it a public disclosure, and that starts the clock and triggers this loss of rights. So what can you do about this? One, as I said, don't disclose public information or enabling information. Use a confidentiality agreement when you get to that stage. And the other is file a patent application before you do these disclosures. So in the tech transfer office, whenever we get an invention disclosure, we ask on the form, and then we ask again in our first interaction with the inventors, like, do you have any planned public disclosures? And we explain what public disclosure means. It's like, yeah, I'm presenting this at a conference next week. It's like, okay, we'll file a provisional patent application that day or the day before. So as long as you file that the day before, you protect your rights to file later in other countries. You don't start the clock you start the clock in the US, but you've already filed before. So always keep your tech transfer office informed of when you're going to have a public disclosure. If you're filing your own provisional patent application, file it before you have a public disclosure, or try not to disclose enabling details for as long as you can. So I'll pause there. I could go into more detail on patent timing and strategy and so on, but I'll just see if that generates any questions.
Well, actually, there is one in chat. When should we go for a patent, and when should we just go for complete secrecy? Patents include the details and are publicly viewable, right?
Yeah, good question. Very good question. So patenting strategy depends a great deal on the nature of your technology. And in some fields like medicine, you absolutely need a patent because it takes so long to get to market. It takes so much investment that if you don't have a patent and the ability to exclude others from practicing it, nobody's going to invest in you. In some other fields like software, it's more ambiguous. So most software products actually go to market without a patent. It's like the field changes so quickly. By the time you get a patent, it might take 3 years or more to get a patent. The field has already moved on and you've spent all that money for something that's useless. Some fields like chemistry, it's like a lot of the value is in knowing how to tweak things, like what temperature and timing and pressures and things like that. And you don't want other people to just be able to read your patent and go ahead and do that. So if you feel somewhat confident that nobody's going to be able to recreate the invention, then try to keep it a trade secret as a chemical thing, for example. I'll pause there, see if that answered the question or if you have more questions.
So David, there was one right before that about why don't investors like LLCs?
Yeah, so let me answer that, and then I want to come back to the IP because I think that it's frothy. Investors, it's actually a specific kind of investor. It's VCs. Venture capitalists don't like the LLCs as a general matter. It's because they have issues from a tax perspective. Because they have, as a general matter, they have investors who are plans and nonprofits, and they can't, because the income flows through to them. It creates unrelated business taxable income for them. So for some kinds of investors who are in the VCs, LLCs are troublesome from a tax perspective. There are ways around it. They can create a holding company and a blocker corporation, different things. As a general matter, they don't do it for two reasons. One is tax reasons, and number two is because their ultimate goal is as an IPO, and LLCs got to convert to a C corporation eventually, anyways, to IPO. So VCs generally won't invest in LLCs. Let me spend one more moment. I want to sort of take Reed's on IP and just go back, and I make full confession, I'm not an IP lawyer, but I want to sort of put a circle around that, because I think about the IP parts first in the startup world in three ways, and I want to make sure that everybody sort of at least thinks about what I call the three questions. One is, do I own the IP? Two is, am I infringing somebody else's IP? And three is, how and when do I protect the IP, which is what Reed was sort of addressing in large part. The first one, but the other two should not be ignored, and the first one in particular. The first one is, have I made sure that I own the intellectual property? It's critical. In the university setting, I got to license that IP out of the university, right? And so if it was produced there and the university owns it, I can license it out. I get pretty comfortable with it. But if you have, for example, founders that may have had, if all the founders have well, it's important that all the founders assign the IP to the new company. If they beforehand created ideas, concepts, or other things, and then will assign it in, then somebody outside this little university of this company has some claim on the ownership of the IP. That's a problem. Similarly, and it's not just at the inception, as the founders participate in the company going forward, you want them to assign the IP they create going forward, whether that be through a consulting agreement or an employment agreement or service agreement or something, because everything they create, you want to make sure that it is in the company. Similarly, independent contractors and employees, you want to make sure that they assign all the IP that they create by virtue of them providing services to the company to the company. And you know, it may sound sort of fundamental, but I can tell you that I've been on the other side of many transactions, several, I should say, not many, in which it was a real hold up to a closing, to a sale of a company, because we couldn't track that some of the people who created some of the intellectual property had not signed invention assignments. So I know I'm harping on this, but it's really, really critical that we make sure all the IP gets assigned to the company. And you know, they're hidden sometimes, like some of your employees or independent contractors or founders may have been subject, maybe what they were working on this while they were part-time, while they're working for somebody else. And that other employer had a very broad invention assignment as part of their policies. And they may not even realize it. So you want to do a little due diligence to make sure your co-founders and your employees actually have the ability and the right to assign the IP. Okay, I've harped about that enough, but it's really critical. The second is making sure that you're not infringing somebody else's IP. And so you'll often have, when employees come, you'll make them represent that they're not bringing other people's IP to the company, because you really hate it when they bring for them. Oh, this is easy. I can do this software I did at my other place. Here it is, and they dump it in, right? Not a good result, because you're now infringing somebody else's IP. You know, sometimes you want to take a poke. There may be. It's really unfortunate to develop a business, run a business, and regardless of whether you've decided to patent your invention. And that's a decision you need to make. But it's not funny to wake up one day and find that you're infringing somebody else's patent. And I've had it happen, in which we got pretty close, and then suddenly we get a letter that says, by the way, the operations infringed a patent. And you know, you end up with a few sleepless nights, and you got to figure out a way to work around it if that's the case. So it doesn't hurt to do some kind of search along the way to make sure that what you're doing within range is not infringing somebody else's patent. I'm not suggesting an entire freedom to operate search, but some kind of search around, just to poke around to make sure that you're not hitting head on somebody else's patent is a good thing. So make sure you own the patent, own your IP, make sure you're not infringing somebody's IP. And then to Reed's point, there are lots of different ways to protect it, whether it be copyright, trade secret, patent, or otherwise. And the only point I would make is it's important to develop a strategy or think about that and not do it accidentally. So if you're, you know, as Reed pointed out, if you disclose it, you may have blown the patent protection or the trade secret protection. And you only have so many resources in life and so much money. So it's important to develop a IP strategy fairly early on, and talk with an IP counsel or your counsel about how you're going to protect your IP and when you're going to protect your IP. So with that, I'm seeing things in the chat, so I'll shut up and see if there are any questions.
Just 2 points on this too. We have a full Start Smart for an hour and a half, much more in depth on this subject. And it was taped last year too, so it's in both PITS and CMU's workshop archives. So that if you want to go back and get more in depth about what's involved, how much it costs, how long it takes, what the different types are, the pros and cons. And then secondly, just for CMU students, we have a librarian at CMU that is very adept at doing research in the US patent and international databases, and is more than happy to help you kind of learn how to do that. We'll help you learn how to do that.
And for Pitt students on the call, LaMonica Wiggins is the entrepreneurial librarian at Pitt, and she can steer you into one of many great databases that Pitt has for research purposes.
Hey, Reed, maybe you want to spend 1 minute with them talking about provisional versus non-provisional patents, because I find for startups, provisional patents is an elegant solution that's at least we want to put on people's radar.
Okay, yeah. So provisional patents are 1-year placeholders. You could file if you're an individual inventor where the university doesn't own your IP, you can file them. I think the filing fee is like $65. So you want to follow the template of a patent application, make it look like a patent application, do your research ahead of time, but the actual filing fee is pretty small. So you can file that, and as long as you don't have a public disclosure, when that 1 year expires, you can refile it and start the clock again. So you're spending $65 like for 1 year of coverage. You can follow that up then. It goes away if you don't follow up with a full patent application before it expires in 1 year. So you have a choice of 1 year. Like, do I file a full patent application because I've gotten some traction, I have people who are interested, I've convinced myself this makes sense, and now I have money to work with a patent attorney on a full application? Or do I say, I still don't know the answers to enough questions, but I don't have a public disclosure yet. I'm going to refile a provisional and buy myself another year for $65. So within the tech transfer office, at least at CMU, we almost always start our patent strategy with filing a provisional patent application. And we do that because it makes us more nimble, and it makes that decision less expensive than filing a full patent application. So whether you're doing it on your own or through the university, typically the first step is a provisional patent application. And as I said, that expires in a year. So then you have to decide, is it worth it? Have I convinced myself, or is the tech transfer office convinced, we convinced, that it makes sense to spend much bigger money on a full application? So a full application, you work with outside patent attorneys typically. I mean, it's legally possible to file on your own, but it's better to work with a patent attorney who knows what they're doing. And we typically spend $10,000 to $15,000 on the application process, the first step of the application process. And then what happens is it sort of sits there. The patent examiner doesn't pick it up for a couple of years. When they finally pick it up, they'll look at it, they'll do a couple keyword searches. They say, oh, here's this word I found in this patent, here's this word in this patent. It's obvious that if you combine these two other inventions together, it's your invention. All claims are rejected, back to you. And that's when the discussion really gets started. So then you bring in your patent attorney, you have a discussion, you explain to the patent attorney why the patent examiner just doesn't understand the invention. And they go back to the patent examiner and say, you don't understand the invention, and here's why. And that conversation costs you another $3,000 or $4,000 or $5,000. And then the patent examiner comes out, rejects it again. You go back, another $3,000, $4,000, $5,000. And you might get to the end of this spending $20,000, $25,000 and still have everything rejected and just abandon it. You spend $25,000 in a poker game, you didn't have a winning hand. Or you may get through to an issued patent for that $25,000. Or you may be battling and spend $100,000 to get to an issued patent. So there's a lot of unknowns in the patent process of like how much it's actually going to cost. So you don't want to go down that path unless you feel strongly that a patent is really important and that you think you have a good position to get a strong patent. So it's not something just to do for vanity or because you think your investors want to see that you have a patent. It needs to be thought through and have a good strategy. And all of that, what I just said, is just in the US. So if you file a provisional patent application, a year later, you have an option. If you haven't had a public disclosure before the provisional and you've preserved your rights to file in the rest of the world, when you convert the provisional to a full application, you can either file a full application just in the US, or you can file what's called a PCT application. It stands for Patent Cooperation Treaty. And that is a placeholder at the international level. It covers 100 and some countries. But again, it's just a placeholder. A benefit of that is it starts the process of getting into other countries, and you also will get an examiner to do a search on your patent to see if it's patentable. It's not binding, but at least you get some sort of feedback in a relatively short time. Whereas if you file in the US, it can sit there for 2 years and you don't hear a peep. So you get this international search report, you have some sense, hey, they think it looks novel, or here's a couple things that they found that we didn't know about, whatever. Anyways, so that's the placeholder international level. You still have another step after that, what's called nationalization. You now take that international placeholder and say, I'm going to file it in the US. I'm going to file it in Japan. I'm going to file in Korea. I'm going to file in Taiwan. I'm going to file in China. I'm going to file in Europe. And like all these places have their own filing fees. Many of them have translation costs. The numbers I said for the US, now start multiplying them times each country. So depending on your invention, does it make sense to patent this in other countries? Is it even a subject matter that other countries will allow you to patent? Most countries don't like software patents of any type. US is a little tight, but easier than other countries. So all of this can be a very expensive strategy, but it can be a cornerstone of your business because it gives you a monopoly. It's a legal monopoly to say no one else is allowed to do this thing that I own. So it's the question there, limit on refiling provisionals. As long as you don't have a public disclosure, you can just keep refiling them. We filed 3-4 times in a provisional. At some point, you have to worry that the rest of the world is going to catch up and invent it in that time period when you've abandoned your earlier one, and you won't know it because the provisional patents are not searchable. Even full patent applications are not searchable for 18 months after they're filed. So even if you do the absolute best patent search in the world, you're missing some time period, 18 months when you don't know what's out there. You spend all this money, and then the first time the examiner looks at it is like, oh, somebody filed that 2 months before you, you're toast. David, you were going to jump in there?
No, you're good. You're good. I guess you're good. You're good. That was good.
So I just want to say this because I have to pop off at 6 o'clock for a board meeting, but I've seen a number of questions in there about what do you say in competitions, and pitch contests, that type of thing. And the typical verbiage is just usually using our proprietary technology, which employs AI, machine learning, or a unique chemical compound. We are able to, and then you go on and talk about solving the problem. So as Reed said, just don't disclose the secret sauce. You can just say it's a proprietary, which you have filed.
And let me, and let me even make a stronger point than that. Even with an NDA, don't disclose it. Unless it's really critical. I mean, unless there's a really, really good reason, and even then hesitate. I always say if you have to enforce an NDA, a non-disclosure agreement, then it's like you have fallen out of the bottom of the well and you're yelling for help from the bottom of the well. You're better off not to give disclose the information anyway. Coke has gone through a long time without giving its formula to Coke. It's a trade secret. It doesn't give it. I tell people all the time, don't give the source code to people of your software. Don't give your formula to people. Just don't do it. And the algorithms, just don't give it. Nobody needs it. They can verify how it works. They can verify that it works. They don't have to verify how it works. There are techniques later, if you get into a sale of having a third party look at it with subject to all kinds of protections. But at the end of the day, my point is, just don't give it. The really secret sauce, even with an NDA. Let me point there.
Okay. There were a couple of questions about names. You know,
About
about company, questions about the names, you know, how do you, if you, where is it?
It's how do you claim the name of a business, trademark, patent, or copyright? And is there a way to find out if another business has laid claim to the same name?
Yeah. You want to take this, Rita, or you want me to? I'm happy to.
Why don't you go?
All right. So, that's a trademark question. And so the step one is to see whether it's available. So if, for example, if you're in a form in Delaware or Pennsylvania or whatever, you look to see whether that name is available. Then you can do a trademark search to see where it's being used, and see whether anybody has a competing name having filed. But it's not copyright, it's not just patent, it's a trademark question.
Trademark and incorporation.
Pardon?
Trademark and incorporation.
Incorporation, yes. And so that's why I said you check to see whether that name is in use in the corporation, in the state in which you're going to file, and then you look to see whether somebody else has a trademark on it. I will tell you that I tell people all the time, I worry a lot more about the product or service name than the name of the company. I can change the name of a company fairly readily, and so, but the thing that you're really creating value in is the name of the product and the name of the service. So, that's the one I really want to go off and make sure that is solid.
If I could add a third leg to the stool, David, in addition to incorporation and registration, the domain is critically important.
Absolutely, yes. Thank you.
Internet domain, especially if you have a business that's going to be engaging in e-commerce. So you could build a great company, have your name even copyrighted, but if somebody else owns the domain that you want to use, you either have to, come up with a different domain name or buy your name from, some 12-year-old pimpled kid from Australia or something who squatting on the name.
Thank you. That's an absolute perfect. Yes.
So Aiden has his hand up. So Aiden, do you want to unmute yourself and ask your question?
Sure. Yeah. So if I could clarify, I was asking about the name for a band. So in terms of like the process, that wouldn't as much be a focus, but if there's a band in another state who has trademarked the same name, I know you said that we have to search by state and see if. So
that's for the name of the company, because you're going to register in that state. So you're going to check that state. The trademark, however, is a federal trademark that you can check. So you want to check do a trademark search in the federal trademark search.
Got it.
No, so like for a band, you can have like a different legal name than the performing name. Could be XZ Corporation and a performing name.
Yeah, but you want to be careful. But you want to be careful on that performing name, that you're not infringing on somebody else's trademark.
David, can you speak to, I know in some cases trademarks are given to a niche. In other words, if Kit and I start a company and we're XYZ widgets, and our widgets are in medical devices, and Aiden's band wants to use a similar name in a completely different industry, there's no encroachment. Doesn't mean my attorneys might not send him a cease and desist letter, but how thorough do you have to be with a name and a trademark in terms of other classifications or other categories?
Yeah, so and I'm getting out over my skis on this one, because my sense is that it can't be confusingly similar in the area, but I'm not the expert on that. So actually, I'm going to beg off of that one, frankly, because I'm not an expert on. My sense is you can use it if it's not, and you're not a confusingly similar space. But that's a pretty vague test I just gave you. and it's certainly not the legal test. But for example, if he's in a band and somebody else is doing spaceships, presumably that wouldn't be confusing. But again, I'm way out. I'm not a trademark lawyer, so I don't want to speak to it.
There's a follow-up question about how you can acquire the business name of an abandoned or inactive business in a way that protects you from liability issues.
Yeah, that's hard if it's abandoned, that's easy. If they've abandoned it, if they're no longer registered, you can grab it. The harder situation is if they're sitting on it but they're non-active. Then you got to go buy it from them, and that's not. You got to find somebody to buy it from. Don's point about the pimple, the pimply teenager. You got to go find them and pay them and et cetera. So that's a. But we've done it. We try to track people down who've had trademarks or names, and try to track them down and pay them for it.
And could I ask if you do find yourself in the position where you have to go and track that person down, is there any recommendations you have about how to do that in a way that you're not just open to this other person screwing with you?
I always say if you have to say may I, then it's not. It's just a question of how much. When I've done it, we've done a couple of things. One is that if it's not a problem you have, which if you're a large company, you want to make sure that they don't know you're a large company, and so you want to sort of seem small. Two is you sometimes have a lawyer do it so that you're not, so it's anonymous. So those are some of the tricks, but there's no great secret way to do that. My strong inclination is that if it looks like it's going to be a hassle, find another name. It's not. Here's one more point for a startup. This is a broader point. Edge cases aren't your friend. What I mean by that is that you can't afford claims of litigation. If you get if you're got a claim for infringement of IP or trademark infringement or whatever, you are going to have trouble raising capital, and you're going to have trouble selling the company. Because it's going to freeze you. You can't afford to fight. And so we have to be, as a startup, fairly conservative. So the advice I'm giving you is fairly conservative, but it's actually for your benefit. If the name is confusingly similar, don't use it. If it looks like we're infringing somebody else's patent, but you can claim that maybe we're not because the claims are a little different, and so we need to be clear, because otherwise I'm going to have trouble getting investors in, and I'm going to have trouble selling the company. So you can't afford to fight. Your litigation. If you thought that Reed's description of the cost of pursuing a patent internationally all the way around is a lot of money, try defending a patent litigation, which is clearly in the seven figures.
So David, just to follow up on Aidan's question, if this band that has a similar name didn't go through the effort of registering or trademarking their name, they wouldn't have many claims.
Actually, that's not. There are. You can get a trademark right simply by using it. You don't have to register it. The registering the mark will give you additional rights in addition to the rights you get simply by virtue of using the name.
All right. So even if the other band didn't register it, still liability.
Yes.
So then it just becomes a question of who was using it first.
Correct.
Thank you.
Questions on that? Let me go just maybe a little to the right on IP protection or protection. And it goes to other ways to protect in addition to the formalized ways we've talked about it. And one is confidentiality agreements with people like your employees, and making sure that your employees and founders have the confidentiality agreements. So even though they're not trade secrets, we don't want them walking away from with things like your customer list, your other kinds of whatever it is. So you want your employees and your independent contractors and others to sign confidentiality agreements. Another way to protect is, we often have restricted covenants on our employees, and it's another way to sort of protect the company. And so, you can talk about, and the restricted covenants can include non-competes. So they, when they leave the company, they don't compete with the company for a period of time. They non-solicit, so they can't solicit the employees or the customers of the customers or the customers or employees or suppliers. So that's another way to sort of protect the company against somebody taking some of the assets of the company. And what I'm targeting right now is employees. So, and founders as well, by the way. You want your founders, each of you, to perhaps sign non-competes, non-solicits, and confidentiality agreements. And again, that's intended to protect the company against any of you, whether employees or founders, from walking away from assets of the company down the road. So that's important. And again, investors, buyers are going to look for that too. Let's see. So I can't really, it says, July, it says, I'm having trouble reading the thing. 1 second. I'm reading one of the questions.
Do you think small companies should get a lawyer proactively or reactively when an issue comes up? If proactively, how does one know when the right time is?
Good question. Both, which is that you should have a lawyer up front when you're forming the company to help you think through some of these issues. And what I'm talking about there is making sure that your IP, as an example, is protected, that you own the IP, and that you've addressed those kinds of issues before they happen. But absolutely, if an issue arises, you better get one quickly and deal with it. It's not the kind of thing that you can just put in a drawer and ignore. So it's both. And people ask me all the time, well, when is the right time to get a lawyer? The answer is sort of like a lawyer's billing, early and often. No, I mean, you should get a lawyer early on in the process. You ought to work with lawyers who deal with startup companies, and they can deal with. The next question you ask is, well, how do I pay for that lawyer? And most startup lawyers will work with you to stage the work and the cost in a way that allows you to manage it. And frankly, if they've been through it a bunch of times, then that's not very costly because they know what the hell they're doing. So there's lots of lawyers around here and elsewhere that deal with solely startup companies, but I would recommend that you work with those early, and they can identify some of the issues that we're talking about this evening, as well as others. And so that's what I would do, and that minimizes the risk of some of the bad things that can happen down the road. And there's some nuances. I mean, there's some tax mistakes you can make. There's some that we haven't talked about. There's some contract issues and other things that we can talk about. Let me just, as long as on the NDA thing that Reed was talking about, and I sort of alluded to, that people should sign non-disclosure agreements. One of the mistakes I see people make is that lots of companies they want time periods on and I see you have your hand up. Let me just finish this thought and then I'll get to your question. They have time periods on the non-disclosure. So it says, okay, I'll keep the confidential information confidential for 2 years or 3 years, and thereafter I can disclose it. Well, that actually doesn't do you any good. If I give them a trade secret, I don't want that disclosed in 3 years. I want that kept as long as it's confidential. So that's a mistake that I see people making with the NDAs. And so I really want almost perpetual obligations to keep it confidential, so long as it's confidential. The other piece is that it needs to say that it won't be used for any purpose other than the reason I'm giving it to you. So if you're thinking about doing a joint venture with somebody or something else, a license, and I'm going to give them the confidential information to look at it, I don't want them to use it for any other purpose. I only want them to use it for this purpose, the purpose for which I gave them. Really another important provision. Who has? Aiden, was it you had a question? You had a question.
No, sorry, that was left over from before.
Oh,
David,
okay.
there's questions in chat about non-competes and enforceability.
So non-competes, it's a state-by-state question, by the way. Different states have different rules on non-competes. The one which is likes non-competes, will not enforce non-competes is California, subject to some really minor exceptions. But Pennsylvania is a pretty good example. Non-competes, employment non-competes are generally enforceable in Pennsylvania, provided that there are a couple of things. One is that there's something you give something for. It's called adequate consideration, but you give somebody something in exchange for that non-compete. And by the way, employment is sufficient. If I hire somebody and at the time I hire them, they sign a non-compete, that's adequate consideration. I've given them something for it. By the way, if I hire them and then 2 years later I said, oh, by the way, I want you to sign a non-compete, that's not sufficient. So it has to be at the time I hire them. Really important. So it has to be consideration. It has to be reasonable in duration. So you can't sign somebody, an employee, around for a 10-year non-compete. It has to be reasonable, and usually, you think of somewhere between 1 to 2 years for the employment context being reasonable, just to give you some context of it. If you go much beyond 2 years, it's unlikely to be enforceable in an employment context. And it has to be reasonable in geographic scope, or scope, I'll call it, because the goal of the non-compete is for them not to take the goodwill or whatever is associated with it. So if they, for example, if they only did work in Pennsylvania, and you say this is going to apply to the United States, it's not going to be enforceable in the entire United States. So it has to be reasonable in geography. And I'll say scope, the kinds of things that they can't compete. You can't say you can't if they're a programmer and you say, okay, you can't program for 2 years anywhere, even in Pennsylvania, you say, no, that's not the case. You can't program in the specific area in which you were programming for me. So it's limited scope. But generally, if you limit the period of time, you limit the adequate consideration and limited scope, then non-competes are generally enforceable with employees and founders. If you're selling a company, there's a different set of rules. It is more liberal and enforceable.
There was a question about whether or not, I assume it's someone who's gone ahead and done the incorporation and some other basic documents on their own, whether you recommend a legal sort of audit, so to speak, going to a lawyer and have him take a look at it, and whether or not at that point things can be fixed if you did something wrong.
Yeah, so it's a good question. The answer is yes. I do recommend that they look at it. So I would do that. That is worthwhile doing. I will confess to you that it's much easier for me as a lawyer to actually form a company than review something somebody else did. Because for me to form a company and put it together, anybody who's done it before can do it fairly readily. And so, we're not being real creative. And so we have the documents done, we have basically a package put together. So you just do it. If I have to go look at something somebody else did, then I actually have to think about it. And I have to go and look at every provision and look and make sure it all fits together and all that stuff. That's actually much harder. But yes, I would strongly recommend that you have a lawyer look at it, particularly if you're going to raise capital or move forward, because they need to fix it, get it right.
And I'll just add on to that last part about, if you're raising money, you're going to have what's called a document room that investors will have access to as part of doing their due diligence. They're going to want to see every agreement that you have. And if things aren't right, they'll just walk away from investing in you. So don't think you can hide it under the table. Oh, we messed this up 3 years ago. Oh, well, too late now. Because when you go out to raise money, they're going to look at all those documents, your employment agreements, your IP license, all those things. And if things aren't done properly, they're going to walk away from the deal, or at worse, or maybe say, you need to fix all of this before we're going to consider it.
Or reprice it.
Or reprice it, too.
Yes. Yeah. Other questions in the chat?
I'm not seeing any. I guess
Okay.
one question on timing. Say you're a student who's worked on a project as part of a class. At what point would you say if they're continuing to pursue it, is that the point where they should think about, protecting IP, forming a company, getting people to sign documents? Do they need to do that when they're in class, or is it only when, it's actually looks like it might have a life beyond the class?
Well, it's interesting. So the class thing's an interesting question. If it's been done as sort of a group project of some sort, so there's other people who aren't involved, then you want to get, and you're the one that's going to continue this on, then you want to sort of get that assignment while you're all together at the end of the class or while you're there. Because once people scatter to the wind, you won't hear from them until you're successful. So the longer it gets and the further away from you get, the harder it is to get people to sign pieces of paper. I mean, I remember when I was at CMU as an undergrad doing a project, and suddenly there was an assignment put in front of me. I'm like, what the hell is this about, right? Well, it's because the professor was going to commercialize it, and I had worked on it. And well, guess what? He wanted an assignment, but he did give me bowling lessons in exchange for that. So it was a pretty good quid pro quo. But the point is that so number one, I would get those if you think that it's possible or even likely or even possible that you're going to commercialize it, get those assignments early. And I don't feel that strongly about the corporate formation at that point. You can get the assignment to you, and then you can assign it to the corporation. But it's important to gather that up as early as you can. And when you actually form the entity, it depends on what I'm not. I don't see any hurry to do that until you're going to do something that I worry about liability or something like that. If you're going to commercialize or you're going to or raise capital or do those, then you certainly should form an entity at that point.
And I'll add on with regard to patent filings. If you're going to have a public disclosure of enabling details, file a provisional before that. So that's rule number one. Another rule is if you're talking to investors, the investors are going to want to know, do you have IP protection? And if you could just say, I filed a provisional patent application, they don't have to know really the depth of it or like how it was filed yesterday or whatever, just by saying, oh yeah, I filed a provisional patent application. And they're like, okay, we'll keep talking.
And one more, I'll step on in your world, Reed, and I'm sure you'll. When I talk about ownership and getting that assignment, if there is another inventor, we got to make sure we get that assigned by that inventor, right? And name them as an inventor on the patent, correct? Really important.
So say you have 5 people on your project team, and the definition of inventor from a patent perspective is who came up with the ideas that end up in the claims of the patent. And the claims of the patent are what you're battling with the patent examiner over a legal definition of the novelty. So if you have 5 people and 3 of them came up with ideas that end up defining the novelty of it, and 2 others were doing market research or whatever they were doing, those 3 people have to be named in the patent application, even if they end up not wanting to have anything to do with it. So you have to get their rights assigned to the person who does want to do something to it, because otherwise all 3 of them have an equal right to do it whatever they want with that patent application.
And indeed, if you don't name all the inventors in the application, the patent can be voided, correct? Attacked.
Yes. Yeah, so just
I have
fight
seen
your rival in your group that you hate by leaving them off the patent, because then your patent's invalid or can be invalidated by a challenger.
I mean, a third party. I mean, this is not this is a strange fact pattern, but it has been done, which a third party has attacked a patent because they found out that not all the inventors were named, and they got the patent invalidated. And so your competitor can use that as a means to invalidate your patent. And it has nothing, whether the inventor is interested or not doesn't matter. The fact that you've filed it wrong can invalidate the patent. It is very expensive to invalidate a patent.
That's true if you're like going through litigation, but it can be
But you can,
easy if you catch it in the little window when the patent application is pending and there's basically a public comment period.
yep, fair, yep. I see we're up against 6:26. So let me open up to other questions. Things we didn't touch on, you'd like us to touch on.
So maybe my last question. If you have for example, one paper that you simply forgot, could be a receipt of a transaction receipt or a letter of resignation that you simply forgot to produce. But this thing was supposed to be done maybe 3 months ago, but you find now, no, is it okay to produce the paper and sign it on a previous date?
So backdating documents, which is what you're talking about doing, is not a great practice. And there's a bunch of reasons it's not great, including sometimes people try to do it for tax purposes and all kinds of things. And as a general matter, backdating documents isn't a great idea. Ways around it are to date it today as of a date. So you say, okay, I'm signing something today as of another date, or you can sign it today and confirm that was our intent to do it as of that date. But I'm not a big fan of backdating documents. Is sort of is the answer to that question.
So great. It is possible to, for example, if the lawyer or the auditor finds that another document should have been issued, then it is possible to sign it today as for another date. So
you can yes, but the answer is yes, you can do that. But you'll need to think through the implications as it relates to that issue. As an example, just to take it to its the one that people try most is in options. The one that people go to jail for is issuing options at exercise prices that are, because the exercise price was much lower, they try to backdate options to before the value went up, and so they try to backdate options. That is a no-no. And so what they're really trying to do is do basically a end run around the IRS. And none of us look good in orange jumpsuits. So it's really I want to caution people against backdating documents. It's not a great plan. As another example, people sometimes don't bother, should but don't have a bunch of board resolutions, right? And so the board should have ratified this, and they didn't. You can either go back and backdate minutes, which I don't like to do, or you can have a board minute today that ratifies all those things, which says, okay, I am ratifying today those things that have already happened. And so there are typically ways to solve a failure to sign something beside backdating the document. And so each one has a potential solution, but backdating it is typically not the right answer.
Thank you.
Other questions? Read final words.
So I don't know the audience here. I'll just say, if you're at a university, go to your tech transfer office. They're there to help you figure all this stuff out. And if it's university-owned IP, if not, the Schwartz Entrepreneurship Center at CMU, the Innovation Center at Pitt, there's lots of resources there to help you. And there's more workshops coming up, both in the Smart Start legal series and also in the Connects workshops that are all of these things are open to anybody.
And I would echo that you all should feel free to, I would encourage you to join the rest of the Start Smarts, where we'll take many of the things we talked about today and some others and go into much more depth. Both raising capital, formation, the arrangements between among the founders. We'll go into IP in a little more detail. We'll do contracts. So we'll do lots of different venture capital. So we'll go through each one of those in a little more detail than you heard tonight. But the major point is to, again, remember the two people on your shoulder, the venture capitalist and the buyer. If you do that, you can't go wrong. And with that,
I think we're at the end of our time. So Reed, David, thank you so much.